So I didn't have any interviews at immigration this week, but have been doing quite more consultations regarding employment-based green card possibilities. So more and more potential clients are asking about O1 visas. And I think it's because of all the stuff that's happening with H-1Bs being so much more difficult these days. So one consultation I did this week was with a client who already has an O1 visa, but there, was a change in employment. So they were interested in what other options or what's the next step required to kind of address this problem. So what happened was that the client was sponsored by a company to come to the US and to work under O1. Now, the O1 was approved by immigration without any questions, and there was no issue about whether or not they were qualified. But although the sponsor had asked for the full 3 years of sponsorship and, which USCIS granted, the employment didn't last the full 3 years. Um, and actually, the client stopped working for the sponsor quite a while ago. So by the time they finally decided to deal with this situation and booked a consultation with me, um, it had been quite a while since the employer and the employee parted ways. So the first thing that I asked was, were you aware that, once you stopped working for your petitioner, technically you're not in O1 status anymore? And I don't think the client really was aware of that. They just assumed that because the O1 approval notice was valid for 3 years, they just assumed that they were still in O1 status. And they've been doing other types of work here and there, but not for the sponsor. So I had to tell the client, look, this is not like proper maintenance of your O1 visa. The O1 is a work visa, and like most of the work visas, such as the H-1B, whoever is the petitioner is your employer, and you can't really engage in work for other businesses that are not officially your sponsor. So that was the bad news I had to deliver. Um, I think the client kind of knew that, but they just did not want to, deal with the situation. They were just kind of like putting it off and procrastinating. So, my advice to the client was the sooner you grapple with this, the better it is, because you don't want this issue to remain unaddressed, right? At some point, if immigration finds out that you're not working for your sponsor anymore, it could be a huge problem, and how can immigration find out? Well, I mean, sometimes employers, if they end the employment, they will notify immigration and request that the approval of that work visa be revoked. Not revoked necessarily, but withdrawn. And why would an employer do that? It's to cover their own, it's like a CYA measure. So if that actually happens, then what immigration normally does is they will acknowledge the request from the employer to withdraw it, and sometimes they could take further action regarding the employee. They could, then decide, well, this person is no longer here in the US on a valid work visa. So now that we have this information, what can we do with it? Right now, we are in a very enforcement heavy climate. So, I wouldn't be surprised at all if USCIS were then to try and initiate deportation proceedings for individuals that they now know are not working for their US sponsor anymore. Um, So that was part of what we talked about during the consultation. The question of, did your employer notify immigration that you are no longer working for them? And if that's the case, then you really need to kind of be careful about next steps, especially when it comes to travel outside the US. Now, if someone is on a work visa and they decide they have to travel outside the US, when they are coming back to the US on that work visa, they're pretty much the assumption is that they are coming back to the US to resume working for that sponsor. Now, if the job is no longer, you know, if they're no longer working for their sponsor, then there are risks with using that visa to travel and come back to the US. CBP at the airport can ask that person, are you still working for your sponsor? Right? And how do you answer that question if you aren't working for your sponsor? You need to answer truthfully. So that's not a situation that I would recommend a client continue to travel in and out of the US on a work visa when the employer slash petitioner is no longer their current employer. So, if CBP were to find out that someone is entering the US on a work visa but not working for their sponsor, that's not good. And CBP can take certain measures like cancel that visa or something along those lines. So just be very careful about that. Um, so, also because it's a very challenging time in immigration right now. Um, Now that this client hasn't been working for their sponsor for a while, um, we need to figure out like what are the, options moving forward. So one possibility is if someone in this situation has another company who's willing to sponsor them for a new visa, then you could try and file a new O1 with a new petitioner. Um, Had this been done in a timely manner, it would have been a much more straightforward application because in order to transfer your work visa from one company to another, um, timing is important. You want to do it at a time when you are still maintaining status, meaning while you're still working for the same sponsor, or if that's not the case anymore, you want to file ideally as soon as possible once that employment is over. We don't want there to be a huge gap in time. So immigration does look at the timing of these transfer petitions, and there's a chance that they could ask for proof that you have been maintaining your status. And what does that mean? Typically, they want to see um, pay stubs, payroll records, proof that, you know, around the time that you filed the transfer petition, you were still working for your employer. For H-1B transfers, there is a recognized grace period of 60 days. Does that apply to all other work visas? Officially, no. But my rule of thumb is, you would want to file a transfer petition as soon as you can. Because the longer that there is a gap in time, the more possibility immigration could question whether or not you were in valid non-immigrant status when you filed the petition. And if immigration doesn't think that you were, they could deny the underlying request to extend your stay. So just be careful of that. Um, that was one O1 consultation. The other possibility is that, and I've been talking about this more and more because, especially for clients who are able to start their own business in the United States, one thing about the O1 is that um, immigrants who are, let's say, entrepreneurs can start their own business in the US And then once that business is established, they can have that business serve as the petitioner for work visa petitions. This doesn't only apply to O1s. It's doable also for H-1B visas and other types of work visas. But I think for O1, it's especially like an attractive option. You know, a lot of my clients who are in O1 status are O1B clients, clients who are in the arts, creative fields, designers, graphic designers, architects, creative directors. So for the clients that I have helped in the past, it wasn't too difficult for them to start their own studio, um, design studio. And then once that is set up, then they can then have their own company serve as the petitioner. This provides a lot of freedom and flexibility to clients because they're not beholden to any one employer who can, let's say, decide, oh, well, this isn't working out. So we're going to lay you off or fire you. So you have a lot more control in the immigration process. So it's not that difficult in the O1 context to have your own company serve as the petitioner. The one thing I would recommend is that you have someone in your company serve as the signatory or the person who's signing the O1 petition forms that are going to be filed with USCIS. You should not be signing the forms yourself because you are the one who is the beneficiary seeking the O1 visa. So, I've had actually a few other consultations for O1 this week. So it seems that there's more and more interest in this area. Another consultation I did was for actually an existing client of mine who has been on O1 status for several years, and I've represented her for every extension. But this time the request was, is it possible, instead of just applying for another 1-year extension, can we try for a 3-year? Because the thing with O1 visas, O1 petitions is, you know, if it's a straight extension, then immigration will only approve it for 1 year at a time. But if it's a new O1 petition, then you can potentially request the full 3 years. Um, Generally speaking, the rule is that if there is no real change in what you're doing, like if you're doing the same job and if you're being sponsored by the same company, chances are you could only request a 1-year extension. But if there has been a material change in your work, so let's say you have a new O1 sponsor or your role has changed materially, you may be able to request 3 years if you can distinguish that what you're doing now is substantially different from, what you were doing on your current O1. So that's one of the options we're looking into is seeing whether or not what my client is doing now is different enough from what she was doing before. It is still the same employer sponsor. So unfortunately, we can't argue that it's a new petitioner, but we're trying to see if her new role as it's evolved throughout the years can be distinguishable enough to request the 3 years. Because it is kind of a pain to have to like renew your own 1 year after year after year. And on top of that, depending on the beneficiary's country of citizenship, if an O1 visa holder needed to travel outside the US and then apply for a new O1 visa in the US Embassy in the home country, you also need to figure out what are the visa reciprocity rules with that particular country. So for citizens of China, for example, if a Chinese citizen is approved for an O1 visa and they want to apply for the physical visa to be placed in their passport, I believe the reciprocity is only 3 months. So that visa is only good for 3 months, and you can only travel in that 3 month window. If you are a frequent traveler and you're a citizen of China with an O1 visa, unfortunately, you're spending a lot of time having to apply for new visas because they expire every 3 months. Um, so just some things to think about if you're thinking about O1. But I have a feeling that more and more clients are going to look at the O1 as a possible work visa. Um, it's one of my favorite work visas just because there's a lot of flexibility. Unlike the H-1B, there's no lottery. Um, you don't, there's no like cap or quota as to how many years you can work in O1 status. Whereas with the H-1B, generally it's a max of 6 years. I once had a client who had an O1 for about 20 years, and he simply just, was not interested in applying for a green card. The nature of his work required him to travel all the time. So even if you were to apply for a green card and you got it, once you are a green card holder, you're subject to the rules to maintain physical presence and continuous residence. So if you are traveling all the time in and out of the US, that might be difficult to maintain your green card. So O1, you can have O1 status indefinitely. You just would basically renew it or apply for new O1s for however long you want. Not really an issue in the eyes of USCIS or CBP. Um, at least as far as my experience, I've never had a CBP officer tell my client, why are you still on O1? Why haven't you applied for a green card? So, the O1 has a lot more flexibility in my view than other work visas. The other unique thing about the O1 is that it allows for an agent to be the petitioner. Um, so an agent can pretty much be anybody. It can also be an entity, as long as that agent has the consent of both the O1 beneficiary and the employer or employers who want to employ the O1 beneficiary. So as long as all the parties involved um, designate one person or one entity to serve as the O1 agent for purposes of filing the O1 petition with USCIS, um, then USCIS will recognize that person or entity as the official agent for the O1 filing. Now, why would someone want an agent to file an O1? Um, One scenario is if, let's say, there's an O1 client and they do a lot of different types of work for different companies, right? They don't just have one full-time job. So for a lot of my clients who are creatives, they might be working on multiple projects and they don't have just one employer. They are working for multiple clients. So having one agent serve for purposes of filing one petition, but listing out all of these projects, that seems to work the best, right? Another reason is some employers may not feel comfortable being the official sponsor for an O1 petition. I've had employers say to me, well, isn't that impossible? The O1 standard is so high. And don't you have to be like a Nobel Peace Prize winner in order to qualify for an O1? That's not the case. But even after telling employers, it's really not that high of a standard where you literally have to be like a Nobel or Oscar winner. There are other ways to qualify for an O1. A lot of employers are still hesitant to file something with immigration because they're worried about what if it's denied? What if USCIS thinks it's a frivolous application? Will there be any kind of blowback on us? Well, we don't want to be listed on record with USCIS as filing an O1 that was ultimately denied. So, some employers can be very conservative, and if it's a visa they've never heard of, they don't feel comfortable going forward with it. But like I've had a few clients where we had that response from an employer. But once we explained, well, you don't have to be the official petitioner. There is an agent who is willing to file the O1. All we would need from you is just a simple written confirmation that you are one of the potential employers if this O1 petition is approved, and you authorize person A or entity A to be the agent who will be filing the O1 petition. So on a few occasions, I've been able to convince employers to be on board for that. Um, Provide a letter confirming that they will employ the O1 beneficiary, and then gotten the O1 approved. So in some cases, it might require a little explaining to companies who are hesitant, never heard of the O1. Um, but you know, assuming that the employers can eventually understand that the O1 is a visa that is not impossible to qualify for. The O1, I would encourage anyone who's interested in looking into that.